Hello and welcome everybody to the monthly knowledge webinar conducted by Kelp along with the Indian Lawyers Association. For all those who are here on this platform for the very first time, I'll quickly brief you about what this knowledge webinar is all about. So we at Kelp along with the Indian Lawyers Association choose a topic from the PoSH Act or related subject matter and discuss over the same. We also call upon industry specialists as panelists to pour in their experiences and knowledges regarding the chosen topic. About Indian Lawyers Association, they have their chapters all over India and requesting all the lawyers and law students to join in and help their community grow. We have two extremely talented individuals as our panelists for the day. First one is Advocate Noopur Singhal. Noopur is a practicing advocate in the courts of Delhi since 2007 with a law degree from Campus Law Center, Delhi University. In 2016, she was appointed as a chairperson of the LCC under the PoSH Act and is now serving her third term there. In December 2020, she joined the WICC and later launched the Uttar Pradesh Anti-Sexual Harassment Council in the March 2021. She also founded Sashakta Minds, a firm dedicated to raising awareness and providing training on PoSH and Boxer. Hello and welcome, Noopur.
Thank you.
Our second panelist for the day is Advocate Namrata Mishra. She's the director of an e-learning company, a POXO lawyer, trainer, mentor, as well as PoSH enabler and family law practitioner. She's the chairperson of the ICC at Torrent Power Corporation Limited, Agra, and serves as an external member for the various organizations under PoSH. Namrata also holds leadership roles as president of Indian Lawyers Association, Agra chapter, vice president of WICC Anti-Sexual Harassment Council UP, and serves as a state councillor for the Women Helpline 1090 with UP Police and UNICEF, and legal advisor to the UP Crime Control Council, Lucknow. She has conducted over 650 plus legal literacy workshops across India. Hello and welcome, Namrata. We also have, hello. We also have our very own in-house expert, our CEO, Smita Shetty Kapoor. She shall also guide us today on this topic. Hello, Smita.
Hey, thank you, Sakshi. Happy to be here always.
So our topic for the day is monetary compensation in PoSH cases. Though the PoSH Act has dedicated a particular section to monetary compensation, wherein the IC and the LCC have regards to decide the amount of monetary compensation to be provided to the complainant when it comes to sexual harassment cases, we feel this is a very undiscovered and untouched topic. Many ICs are still unsure how to determine the monetary compensation that they would want to pay the complainant, wherein the complainant complains about having mental distress or mental trauma because of the sexual harassment. Hence, here we are throwing some light on this topic and discussing over the same. Before moving into the actual discussion, I would quickly want to remind everybody the registration for PoSH Awards will be ending really soon, requesting all of the participants to encourage their organizations to register for the same and get a chance to be recognized as one of the top 25 safest workplaces in India. Quickly moving into the discussions, I would like to pose the first question to Namrata. Namrata, how does the PoSH Act define or regulate compensation for victims of sexual harassment?
Okay. Thank you, Sakshi. First of all, I would like to begin by expressing my gratitude to Kelp for inviting me to participate as a panelist over here. And yes, as you said it right, that this topic is, very less discussed. And I am confident that over here with collective brainstorming, on this vital issue, we will offer some valuable insights, for all of us to reflect on and implement. Now, coming to the answer to your question is that PoSH Act per se explicitly doesn't provide a detailed or specific framework, for awarding compensation to the victims of sexual harassment. However, it does empowers the ICs with legit authority to recommend compensation in suitable circumstances. Now, legally speaking, under Section 15 of the PoSH Act, there it says that monetary compensation to the aggrieved woman can be recommended, while the act doesn't specifically exactly say compensation guidelines, and the ICs are authorized to only suggest that compensation be paid to the victims. And as per the rules of PoSH rules, they just say one thing, that inquiry has to be conducted keeping the principles of natural justice in mind. And but it does provide certain guidance on determining compensation for the aggrieved women, and that is on four or five points. And first is, what is the severity of damage that has been caused to the aggrieved woman in terms of the pain or the harm or the suffering that she is, emotional distress that she is going through because of the as a consequence of that action. And the second is the loss of her job opportunity and career options. And also third is medical expenses, that she, whether she's going and taking any therapies, she's taking any treatments to her physical injury or any psychological injury, or whether she is so emotionally distressed that she has to seek psychiatric counseling. So all these factors, along with, also IC has to also consider that what is the income and what is the financial reputation of the respondent. And last point which the IC has to consider is that, what is the feasibility of awarding such compensation? Whether they can award that compensation, in one go as a lump sum, or whether respondent won't be able to pay that. So, can they, recommend that the respondent can pay it in installments, and whether whatever monetary compensation, if they think that is justified and it justifies whatever has happened with the aggrieved woman by awarding monetary compensation to her. So whether it's justified, so that they have to again review and analyze, and then they can recommend it.
Thank you, Namrata. Thank you so much for briefing about all the points mentioned in the Act itself. The next question goes to Noopur. What do you think are the key factors or best practices that determine the amount of monetary compensation in PoSH cases? We can see that we have been given 4 to 5 options, but the amount, the exact monetary compensation, the amount of money that we would actually want to present to the complainant, that's missing in the Act somewhere. So what do you think are the best practices that can work there?
Thank you, Sakshi. And this is very important question because, yes, as we discussed, you rightly said, there is no calculator is given. There's no calculator that you put some variables into it and you will get the, okay, this is the monetary compensation which we have to get. IC has to do it as per their discretion, and the discretion does not mean that it can exceed a lot, that it hamper the even the respondent, that if, for example, we cannot say that a respondent who is earning 50,000 and we impose a penalty or the monetary compensation which we have to deduct from his for 1 crore or something. Okay, that cannot be done. And also we have to also keep in mind what is the impact on the victim. So when we all know in PoSH, we always say that impact matters more than intent. This is the time when we have to actually see this, what is the impact on the victim. And it is not an easy thing to keep it in the monetary terms. It's like everyone, like for example, in Rajikar case, we always say, okay, there is in criminal law, we have a victim compensation scheme. And government always say, okay, something happened, the rape happens like in Arjikar case, and they said, okay, we are offering 1 crore rupees to the victim family. But you cannot quantify that in the monetary terms. It's basically, in my opinion, because we are going as per the opinions only, we have very less precedence on the basis of this. Like we have only, I think, Gayatri Balasubramaniam case, we have global health case, few cases where it has been determined and we have been given how it can be, we can look into the what all components we can look into this, because for point like 2-3 things we have medical expenses and everything. But when you say mental trauma, emotional distress, how you are going to compensate. So IC has to put that discretion. We have to see the impact, what is that going on? If like, for example, if we see there is a psychiatric impact, she has to go to psychiatrist. This means you can see the gravity of the situation. If there is a medical expense, this means physical impact was such that she has to take in this. So the gravity increased in that. So IC has that discretion in that. And IC has to also consider that how the respondent has to act. So for example, if the respondent has left the company, how we are going to recover it? So we can stop the full and final, but till what amount? There has to be amount. So all these things will be considered, and I believe the best practice is what we apply as in local committee. I had followed the global health in one of my matter, where we did they had expelled both the complainant and the harasser without doing the inquiry. So apart from mental trauma and this, we did something, okay, following the global health, but we also considered like the loss of income because she was not relieved properly. Her paperwork was not done. She was not able to do the job till the inquiry was pending because she do not have the proper relieving. So we compensated all that terms. We made calculation at least in that respect. So around some, I think we also had awarded some 25 lakhs and you in one case, and the opposite party, the employer, they challenged it because we had imposed that monetary compensation on the employer for creating the hostile work environment because they had not done the inquiry. So there was a 50,000 penalty for non-compliance, and apart from that, we had given some calculations and also the mental trauma. And then they had challenged it in High Court, but we were hoping, at least in local committee, we can hope that some judgments can be laid down there. We don't have any issue that people are challenging our orders. So we were hoping that some guidelines will be laid down in that, but bad for us that they first hearing only, they said, okay, we are withdrawing, we are okay, ready to pay that. So we did not get judgment, yes, but there was simple order, they agreed.
Okay. Thank you. Thank you so much, Noopur. Smita, would you want to add up to this?
I think Noopur has covered most part of it, but what I can give you from my personal experience, few cases that we dealt with, right? First and foremost is the what Noopur rightly mentioned about the emotional distress a woman will be feeling. Okay, so if an IC, so IC comes, when does an IC come to a point that after they have looked at all the findings, they have corroborated all the data, and now they are finally going to award a punishment. There are series of punishment. One of it is mentioned in the law is monetary outcome, right? Now, in that, as an IC, you have to look at it. Okay, would an IC want to even go that path? If you would have interacted in your conversation with the complainant, with the respondent, and as an IC, do you feel that monetary compensation should be part of it? The things that Noopur rightly said, I'm just summarizing what she said, right? First of all is emotional distress. So is the whole proceeding, is the complaint, the proceeding caused emotional distress to a woman employee? So I think IC should pick up a pen and paper and write it down. Has this led her to, so, MJ Akbar Priya Ramani case, right? They said dignity of a person gets crushed when there is a sexual harassment complaint. So imagine a dignity of a woman getting crushed. So if an IC is believing, yes, this has caused an emotional distress to a woman, and it will take time for her to get back to workplace, to live a normal life, she will need intervention from maybe psychiatrists or any kind of intervention, and there will be expenses to it. List that down. Okay. Second most important aspect is reputational damage. Has this case or the case proceedings, maligned her reputation, and she might not, if she has quit or she wants to continue, for all you know, many women employees, once a case has come, want to drop out. That's not a great thing to do, but I have seen that over a period of time they drop out. So will she continue at workplace? If she drops out, many of these fraternities are so small that news travel, and will she get another job? So there will be, while confidentiality and all that is a different chapter and we don't want to discuss at this stage, but what will be that reputational damage how much time will it take for her to get back to a normal career, normal job? That's the second most important aspect, right? So I think considering these two parts, and there are some cases where women go through psychological trauma, there is abuse that has happened, there are scars. So these scars are scars forever, right? Nothing, no monetary compensation can balance that out at all. But if an IC feels that there is something that needs to be going in there, these are the three aspects that they should look at: emotional distress, reputational damage, and psychological trauma. Now, that is what we have to provide as, and we have to calculate. And I like the way Noopur listed out that we have to look at all these aspects and calculate and figure out what is that amount that we would want to give. But I've also seen in practical aspect that maybe the complainant does not need the monetary. She's okay with a apology note. She's okay that there is some punishment awarded. She feels okay. I've been taken care of. In such scenarios, also sometimes ICs come up with a monetary compensation because they also want to give a strong rap on the person that, you know, this is a behavior which is not tolerated. IC gives out a monetary compensation as a outcome. Though that is collected, meaning, you know, the bonuses are held or something on those lines. Those are then sent to an NGO which works in the space of women and children. Okay, those kind of things are also done. Or the respondent is asked to deposit some money on, you know, over 1 year to a particular NGO. That again, IC calculates basis because they want to ensure that there's a very strong message going to the respondent that this is the last time this kind of behavior should be, and there will be consequences. I think these are the aspects that IC should look at.
Thank you, Smita. So do you also think, like all three of you, I would like to pose this question to all three of you, irrespective of what the IC decides, to provide the monetary compensation or to not, should the IC be reasoning the reasons for deciding anything that they, find out? What should their recommendations be reasoned?
Yes, I think it should be reasoned. They should have proper reasoning to arrive at such a decision.
Yeah, I'm just picking it up from Namrata. Anything that goes in that report, we call it a reasoned order. And there's a reason why we call it a reasoned order. Why do we call it sexual harassment? Why are we awarding a particular punishment? What is the thought process? What does each IC member thinks? Okay, that also should be documented. I think when any of the party, the complainant, respondent, even the management, they should know that this is a thought through judgment, and not just because IC thought on one particular morning they thought that this should be awarded. We've spent a lot of time in coming with that report because we want to ensure that we follow principle of natural justice, and we're not letting even one page left unturned. Yeah.
So I want to just add one thing here, that many times IC do not go into the monetary compensation aspect because they said that complainant has never asked for it. Right. So when she asked it, then we will determine. But if we see the language of section 13, what are the inquiry report and what should be the recommendation? It says actually where the case has been proved, basically, if I read it, the subsection 3, it says that where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation has been proved, it shall recommend to the employer or the DO, as the case may be. So the maybe is for the whether the employer or the district, but shall recommend. And then the 2 is to deduct, notwithstanding anything in the service rules for this monetary compensation. And that has to be as according to the section 15. So monetary compensation has to be taken into account, whether it has to be given or to not to be given. IC has to discuss that in their inquiry report, because that is section 13 is very clear that as per section provision of section 15 कि आप कौन-कौन से aspects ले सकते हो, all those 5 aspects, you have to determine whether you have to pay the monetary compensation or it is not applicable, or if applicable, then to what aspect. That has not been done by many ICs, what I have seen. They just think it is optional thing. But it is not optional. We have to give reasoning whether it has to be applicable or it has to be given or not to be given. Section 13 is very clear on that.
Thank you.
For
Thank
me.
you so much, Noopur. Moving on to the next question. Namrata, I would like to pose this question to you. What is the role of the internal committee in recommending or awarding compensation?
He has already discussed, earlier also, role is a very crucial role, and that has been given to ICs. And as Noopur in our earlier answer has already, and Smita also has thrown this, insight that they have discretionary powers. Okay, so they have to take informed decision. They have to they have to justify how they arrived at it, and this will be as a remedial measure, okay, as provided under section 13, as clearly put by Noopur. So how they will arrive at it, we have to see whether the aggrieved woman is undergoing or is a victim of post traumatic stress disorder. And there are certain cases. Why? Because we are now living in an internet era. Many, despite of the fact the proceedings are all confidential, but still in the workplace, words go out of mouth, and people get to know that who has been sexually violated in the office by whom, and it might disturb the person so much, and that person can also have suicide, not only suicidal thoughts, but they have attempted suicides. So this is extreme step taken by a victim, an aggrieved woman, because of the act that happened to her. So the IC has to consider all these points and make it objective and justify in their informed recommendation that they will give. And there is one very notable case that I would like to cite over here, and this is of Mr. Fanish Murthy. Okay, so a complaint was filed by a former employee against him. He was then the CEO of iGate, okay, for sexual harassment. The complaint was filed. Now, upon inquiry, the IC found him guilty. So this fellow was not only dismissed from his position, but also faced financial repercussions, and which included significant compensation to be given to the aggrieved woman. So this case reinforces the IC's crucial role to hold powerful individuals accountable under PoSH for the act that they have done. And should be a lesson. This should be a deterrent for others not to follow that. And especially in corporate settings, these kind of examples can be set by ICs in the circumstances given. And I think that ICs must be wise enough to balance the need of compensation, which will clearly reflect that how much damage was caused to the person concerned, and why they are justified in awarding monetary compensation to this person.
Thank you. Thank you so much, Noopur. Smita, you wanted to add something there?
Yeah, I just wanted to add one aspect that while monetary compensation, the word says, meaning it is taking from somebody and giving it to somebody. It's a compensation for what they have faced, okay? There are times when, the victim does not want that money. I think either Namrata or Noopur spoke about it, right? They are very satisfied with maybe a termination of any other order, and they don't want money of this person for many reasons, because and this is typically urban condition I'm talking about, where women are self-reliant, they're making their own money, they don't want any compensation from this, they just want to ensure that this behavior is stopped and never repeated, right? In such situations, there are times where IC still feels that maybe there need not be a termination, but there could be severe other implication, which includes maybe a demotion like a thing, maybe a no increments over 1 year, right? In that, there are times when there are bonuses. Many of our organizations give out bonuses, but they do not want this particular person to get it. Now, in such situation, there is a corpus which is created, right? Of bonus, which was supposed to be sent to this person, but now because of IC's order, it is held. Now, I have a very strong recommendation to all, and this is what I tell everybody, that, it shouldn't be a pity of the employer, right? It should go for this cause. And that is why this NGO, and I'm answering a question which was raised by, I think Suchitra raised that question, that corpus should be sent to an NGO. The organization can determine. It could be an NGO which is working in the space for women and children, or if you Kelp can recommend for you. There are multiple organizations which are working in the space of women empowerment. It has to be sent to them is my strong recommendation. Is it mentioned anywhere in the law? It is not. But I think it should not become one more tactic of holding back money. You know how one leads to another, and there are these chances of not taking the law in the right spirit. Yeah. So this is what I wanted to bring it out.
Thank you. Thank you so much, Smita. Moving on, I would like to pose the next question to Noopur. Can a complainant challenge the compensation amount decided by the ICC? And what are the legal options that a complainant have? Like for a very recent case that happened of a very famous television story, that was Jennifer Mystery. I would like to quote that here. I think that's out in the public already. Wherein she wasn't happy with the amount of compensation that they provided. And she was like, I'm not satisfied because this is not equivalent to the kind of trauma I went through, though it was aborted by the LCC. So, what do you think the complainant here has an option to, challenge the decision of the IC while recommending this monetary compensation?
Yeah, so actually, complainant as well as respondent both can challenge it legally, because every recommendations can be challenged in appeal. And yes, they have to go to the court of appeal. What we have discussed, we already know under PoSH, whether it will be industrial tribunal or the labor court or the high court as per the different states. And you rightly said, so there can be many aspects on which it can be challenged. So yes, like Jennifer Mystery case, you said emotional trauma, she's saying she had not been equally compensated. But there are other factors also. So for example, I recently know a case, sometimes when people go in a job, in their contract, they have been promised many things, that they will be giving quarterly this increment or that increment, or these will be, there are different terminologies which we go, and they were promised many things. But if they suddenly got terminated or something, like on the compensation part for the complainant, they do not, because many times they happen in local committee, we get in the case against by the complainant when they had been removed from the job. Otherwise, it very rarely happen that they are coming to the local committee, they will against the employer, they will go into the IC only. So I'll give for the perspective of the local committee right now here. So when they do not get all those things which have been promised and they have been terminated, and or they were not able to perform, the impact was so high that because of this reason, and because of maybe the 3 months inquiry time or which were going on, their performance got dropped, and their the ACR which was to be happened at the 5 rating, they got dropped to the 4 or 2%. And because of that, their performance or the bonuses get challenged, and it can that should be even the considered by the IC. So in our practices, in not even in the ICs, what we do at the first case, when we get the case, what we do, we brought the these files of the personal files of the complainant and the respondent, so that they cannot take the this guard that she is not performing. Right. So
Yes.
we actually get hold of it, like first tell us what is her performance, so that they should not be impacted. And that also can be looked into. If so, for example, so I'm giving just one example, it get dropped, and otherwise she was a good employee who would have get the 5 rating. So that can also be given. And if the IC overlooked that, that can also be challenged. So yes, complainant and can challenge it legally on these aspects or different aspects on what all points she is asking this. And yes, emotional distress is one thing, like Jennifer Mystery said, yes, because she might be not, her reputation has got so much damage that she's not getting any work anywhere else, because she is now termed as problem creator.
Yes.
The terminology, that why we keep, yeah, you are very good, but we do not want to hire her because she's a problem creator. Then she is not getting, no one say on her face that yes, we do not want to hire her, but her damn reputation has gone into so yeah, that should be taken into account, and she is rightly challenged it.
True. Very true. Thank you. Thank you so much, Noopur.
Actually, Sakshi, just adding to
yes.
Jennifer
Sure,
Misty's
sure,
paper,
Smita.
I was following it. What I read was when she filed a sexual harassment complaint, the compensation which was due to her was stopped. And what was the outcome that was given was that that needs to be released. That's not a compensation. She only got what was due to her, right?
Her
So
fees are actually the fees that she was entitled to.
so she didn't get any compensation. And as Noopur rightly said, she was not adequately compensated. She lost. I mean, the day before yesterday, I was flicking channel and I see the person who was named is in that serial. I'm like, oh my God. And this poor woman doesn't have a job and we don't see her in any serials. I don't know. I don't see all, but I don't see her much there. Okay. Yeah.
So it shuts down their future opportunities that they would actually be entitled if they wouldn't have raised their voice, honestly. Thank you. Thank you so much, Smita. Moving on to Namrata. To what extent is the employer liable for compensating victims of harassment under the PoSH Act?
Okay.
Do you think the
Under
employer has any role to play here?
See, yes, under PoSH, the employer holds a significant responsibility again, according to me, in ensuring a safe workplace. So this is they have to adhere to the PoSH, a legal framework, and if they do not comply with it, then is the employer, whose responsibility it was to not to create a hostile working environment, but a safe environment. So this extend to their potential liability for compensating victims of workplace harassment as well. Why? Because as I already mentioned that they are duty bound to implement PoSH framework under section 3.2 and under section 19.1, and they have to comply with mandatory legal obligations. If they do not, so they attract penalties as mentioned under the law. But after the IC does its job of inquiry, and it is the responsibility of the employer for ensuring that the compensation is duly paid to the aggrieved woman by the respondent. So the employer that way is liable, and although PoSH Act doesn't explicitly provide for vicarious liability of employers as in other cases, but the Indian courts have in some instances held the employers accountable under the doctrine of vicarious liability when they fail to act against workplace harassment and they did not take appropriate preventive measures. So when the matter only had gone to the court, then the courts tried to impose this and made the employers realize that they have their vicarious liability, and if an employer's negligently allowed a hostile work environment or failed to comply any prior recommendation by the ICC, so the courts have ordered to compensate the aggrieved women. Take for example the Supreme Court in the recent hospital case that happened. The Supreme Court has stated, I will just quote, that if a woman is not able to go to work and working in conditions are not safe, so we are denying them equality. These are the apex court's words. And they have also issued directions for constitution of task force, not only in this particular case in this particular hospital, but for all hospitals across the country henceforth. And they want that PoSH compliance should be strictly dealt with now, and no dilly dallying and no hunky dory that ways, and they need to be implemented. So if a workplace need to be safe and secure for all employees, this is the primary responsibility of the employer to provide such kind of safe environment where all employees are working in a harassment free atmosphere.
Thank you. Thank you. Thank you so much, Namrata. Noopur, would you like to add on something to that?
Yeah, actually, I want to add because your question is to what extent employer is liable for compensating the victim. So basically, employer are liable for compensating for the non-compliance basically aspect. So when they do not comply with the law, mandatory law, and the responsibilities of employer are actually very well given in the act. So for example, if they had tried, so they have to produce the respondent and the witnesses. They have to produce all the necessary facilities. They have to give necessary facilities to the IC. So even the confidentiality aspect has to be maintained by the checked and by the employer. They have to provide the CCTV footage or everything. They cannot just say that, oh, we keep it only for 72 hours. We do not have it for that 90 days period. That is the non-compliance of act. And yes, there is a limit for non-compliance that is given of 50,000, or for twice, it can be twice the higher for on the second time. So there is a limit cap. However, like in Global Medan hospital case, which we know and everyone knows in MP High Court, there was a non-compliance that they had not constituted the IC, and they had actually lied to the DO office when they issued the show cause notice that we have the IC. So the local committee checked and they found that there is no IC. So basically non-compliance of act. So again, penalty can be increased by the courts in the writ jurisdiction. They have that power. But as an local committee or any other committee for non-compliance, IC rarely impose any penalty on employer. Because they are actually constituted by employer, I doubt that any IC, I have not seen any internal committee imposing any penalty on the employer. However, I have seen, because I give consultation to the complainant when they come to us. For these non-compliances, you have to approach the district officer, because he is the monitoring and the implementing authority. So you approach there that no, my employer is not doing it. And they also go very rarely, even in the only in the cases when they have been terminated. So only in that cases actually the employer they get penalized, which has been given in the act.
Thank you so much, Noopur. Moving on. Next question also I would like to pose to Noopur herself.
Okay.
What should the complainant or the external member keep in mind while encouraging compensation? So if the external member has been asked, or if the complainant says that, okay, you tell us, what do you think should be the monetary compensation that you would want us to, pose? So do you think there are certain things that these complainants and the external members also should have in mind while they, keep out this option that, okay, we can quote this amount to this particular respondent?
Okay, so I'll just share one of the incident in one case which we had. I was the external member there, and that organization was about to shut in 7 days when we received the complaint. And we received a complaint, so we have to comply everything within 7 days. We received a complaint, we sent it to the respondent that, okay, because this is the scenario, you have to reply in 2 days, and he replied. And the inquiry proceedings we actually conducted on the last day, the whole day, when till 10 o'clock in the night. And we asked, actually, when we asked for the conciliation, whether she wants conciliation or that, she said, I want this person to recognize. Do not want conciliation, but I want inquiry. I want this to be established that this is a sexual harassment, and I do not want any compensation. I want this person to understand that what he has done is wrong. I just want apology. I do not want anything. And that person adamant that yes, I said this, but I'm not going to apologize. I said this, but I'm not going to apologize. I do not think that I had done anything wrong here. And we as an IC, we thought, yes, this is actually a case of this. And he is adamant, and she wants only apology. She said, I do not want anything else, not even the monetary compensation. So what, as an external member, I suggested, and what the IC members are, that we have to give compensation here to because that is the last day. They are actually shutting down. Everyone was relieved. They were only holding back for this inquiry. So we suggested them that, okay, we are then going to have the monetary compensation. So for the deterrent effect, that you should realize it actually, that you are going to face this at least. This you cannot just relieve, okay, I'm the anyways relieved now, my job is over. But it should have the deterrent effect if you do not do this. And that is the point when we kept in mind, because deterrent is also very important. Yeah, that person should have the deterrent effect. And then he realized, okay, this can also be done. he never thought that, okay, then he was, okay, I have to talk with my mother and I'll take some guidance there. What should we do when they, and somehow that we did. So as an external member, we have to give, think how to, so that how to go about these type of situations, in keeping mind why we have to put the monetary compensation when everything else is not working out also. Then this might be the thing which works out, because that actually pinches a lot. And why that? Because if I say that was a hospitality industry and he was merely earning around some 20,000. And when we said we are going to deduct 10,000, that affects a lot.
Yes.
That was a deterrent effect. That affects a lot. And that puts something in their mind. Yes, okay, this has a huge impact, this action. So I'm sure that he, for the next time, he will keep that in mind, that even that can be done.
Sometimes strict actions actually work to make the
Right.
opposite person realize what the, we can do that actually. Yes. Smita, would you want to add something here? I think we lost her. Okay,
She's here, but
yeah.
No, she's
I'm
here.
sorry, I think there is a little lag. Sorry. Sakshi, can you repeat your question? I'm so sorry.
Sure, Smita. So as we were just discussing that, is how do we, so as Noopur mentioned that this respondent was like, okay, any which ways I'm going to be relieved. So there's no point, they cannot do anything major with me. But then the LCC decided, okay, you're 20 out of the 20,000 salary that you are being paid, we are deducting 10,000. And that actually created an, deterrent effect there.
Absolutely. And that's exactly what I was saying, right? There are times when the complainant does not want a monetary compensation, but to ensure that this person, it's a tight trap on the knuckles, I'm sorry for using a language which is used, but it really reminds them that, this is something that cannot be tolerated. Actually, I'm remembering another interesting incident, okay, where one of the complainant had come to us saying that she had gotten her WhatsApp data erased. Okay, the WhatsApp data was not available with her, and she's trying her ways to get it, but it will need 50,000 rupees to be paid for it. Okay, now we were like, okay, how do you want us to help, right? So she was saying that
Smita, you're stuck. Oh, is it just me or Smita is Smita?
okay,
Yeah,
Smita,
she's
you were
stuck.
stuck. We lost you.
I'm so sorry. I think there's some internet challenge. Could you hear me now?
Yes, we can hear
Yeah.
you.
So she came to us and said that if I'm able to prove the particular thing because I got the WhatsApp retrieve, will you be able to compensate that 50,000 rupees back? It was a live case with us. And we took a pause because something very different out of the box completely, right? So we took a pause. We got together as an IC, we brainstormed, we went back to her and said, listen, if you are able to prove it, we'll be able to compensate it by taking it from the respondent. Now, it was a very unique case, right? So this is something I thought it will be good for our audiences also.
We would want to know, was it established?
No, we didn't need to go that way because we were hanging on only that
Piece of
out-
information.
yeah, that piece of information. But fortunately for us, there were series of other things which helped us determine in the meantime. So we told her, don't go that route. We found this. Yeah.
Thank you. Thank you so much, Smita. Next question I would like to pose to Namrata. Now, how can organizations balance fair compensation for victims while safeguarding themselves from excessive claims? Now,
Very important questions. Yeah. I must say, good question. So, answer is very simple. Organizations can adopt proactive, structured, and transparent policies and approach, in fact, to manage such cases under PoSH. And there are certain key strategies and there are certain pointers that I would like to, speak over here. First is they have to be clear and comprehensive and well-defined PoSH policies. So they have to formulate clear, but a bit detailed and robust and well-defined PoSH policies. By this, I mean that they must clearly state the process of handling complaints, and they must also, in that policy, write what shall be the criteria for compensation, and also include monetary compensation in it, and consequences of violations of such criterias, and of course regular training and awareness, that also should be mentioned, and it really helps. So this step will actually ensure transparency in how cases can be handled. Second, also very important point that I feel is that IC's expertise also play a very crucial role over here. So we need ICs who are experienced and who are unbiased and who are skilled and adept in handling such kind of cases. So they have that kind of bandwidth to analyze such cases and arrive at a rational decision, a rational informed recommendation they can make. And the third point is structured criteria for compensation as per the PoSH rules must be considered strictly, and this also ensures fairness. Next point is they must maintain detailed records. So very good policy, a very good thing that an organization can do, that they can create a clear paper trail. If they document everything, if they document each and every inquiries, recommendations, decisions, and what action taken, if they document it in there for their internal thing only, for their internal safety, for their internal environment only, then it will not only ensure evidence in case there is any dispute, because the aggrieved woman also has the right that she can file against, she can appeal against the recommendation also. So they must maintain all these records, and this also reduces the risk of being perceived as a negligent employer. So as a proof, it's always good and recommended that they create a clear paper trail, organizations. Next point is they must cap, if they can, cap on compensation amounts. Now this is something which might be useful for the organizations, because if an organization sets reasonable limits on compensation based on the severity, then it might help them, and it might clear the ambiguity also as of now. So, and also I feel that they can be objective when it comes to compensation assessment. How they can be objective in such a subjective consequence like emotional distress? Well, they can ensure that the aggrieved woman is fairly compensated, and organization must ensure that the decision is completely proportionate to the harm that is caused, and also whether the respondent is able to pay back to the aggrieved woman or not. Like suppose Noopur has stated that the person only receives 20,000 rupees as salary. If we are imposing and awarding a penalty on him or in monetary compensation that he has to give to the aggrieved woman to the tune of 2 to 3 lakhs, it will be difficult for that person to give that amount of money. Is all must be also exorbitant for such a person. So we have to see whether this person is in a paying capacity to give that compensation, whatever is decided by the ICs. And the last point, according to me, is that clear appeal process is already there, but also in the policies we must write that allow either party, either the aggrieved woman or even the respondent or the employer, can challenge the IC's decision in an appropriate legal forum. And this offers a check against unreasonable and arbitrary, IC decisions. Otherwise, I mean, for the sake of policy, I'm saying it, but otherwise, we hardly come across ICs who commit such kind of grave error of judgment, through their analysis. ICs generally really come out with some very good and very reasonable recommendations, as per my experience. So I would just in a nutshell, I will just say one thing, that for employers, ensuring that compliance with the PoSH framework is not just their legal obligation, but it is a commitment to creating a safe and respectful workplace for all employees.
Thank you so much, Namrata. The last question.
Sakshi, I actually
Sure,
wanted
sure,
to
sure.
send. No, before adding, I actually want you to explain your question here. When you say that excessive claims and the employer has to safeguard, what do you mean by that?
So
What?
if at all in a situation, if you feel that, okay, the kind of mental trauma, physical distress, or any kind of act which the complainant is saying that I went through and I want a monetary compensation for the same, and if actually, see that, okay, this is not, the amount that she's asking is too much for what she actually went through. If as a prudent person, we can determine that really well. So in that situation, we think, okay, she's actually asking for a very huge amount. And I don't think this is what, at this point of time, neither the IC or the respondent can actually pay out. So can we push back the complainant there? Can we say that, okay, listen, we understand you went through this, but do you think this is, okay for you to ask for such a huge amount? Some people, there might be situations where a complainant feels, okay, this is the right time, maybe I can have an option here. I can ask for a huge sum. And because this is a sexual harassment case, maybe the IC would actually rule out in my favor.
Right. So may I just want to add something here, that actually IC is not a rubber stamp. So thank you for first the clarifying your question. So IC is not the rubber stamp that whatever the complainant is asking, IC has to give.
Yes.
It's the IC discretion. And sorry, Namrata, but I do not agree with your point that it has to be capped in the policy. Because as I said earlier in our
Suggestion.
discussion, it's just we are discussing things, and I'm sharing my understanding is. When I started with this, I shared before this started, that when I started with my PoSH journey, and my understanding was this act is very vague. It's very unclear how to go about this, how to interpret this. We do not have anything in this because it was fairly new act, still very new act. But now what my understanding after some 8 years is, there's that, thank you, this act is vague because we have so much for interpretation, and that is the discretion which IC have. So, and IC, as I said, IC is not a rubber stamp that if she's asking 25 crores, we have to give 25 crores. It has to be reasonable, and that is the IC discretion. And we should not cap it. We should train our IC in a manner that they should come to a fair, reasonable compensation. And if we are giving our reasons, we are giving the reasoned orders, there is no way, there's no thing that we should cap it in any condition, that we are going only 10 lakhs, or because then we are making it a rigid, that okay, we cannot determine exactly, the law did not determine it, how can we as in policy determine it? Please remember, it's a beneficial act. It's a beneficial act for the victim. We cannot say, okay, this is a physical, he had touched you, you will get 10,000. Oh, he had kissed you, you will get 20,000. We cannot cap it in any such manner. We cannot do that. We cannot determine it. Let it leave it to IC discretion, to their intelligence. We have to give them skill capability trainings and everything, that how to give the reasons why they are coming on such conclusion or the such compensation.
So
So
like to
that is
sum
what.
it all, I think it is very important to have a trained IC to give a logical reasoning. It
Yeah,
ends
right.
there. It sums up there. It's
Absolutely.
Smita.
I just want to add something to what Namrata and Noopur said, when I started my journey I was part of Vishaka Guide when Vishaka Guidelines was implemented. And then when the law came in, I was there. And when the law came in Vishaka, we didn't have financial aspect. There was
Conversations.
no monetary compensation at all. But when law came in, the monetary compensation came. Trust me, my first reaction was that it will get manipulated. People will use it for their own reasons, right? I never ever even spoke about it in my conversations with when we were doing employee awareness. We did not speak about it. Because at the back of our mind, we thought monetary compensation cannot help a victim in any way. But over a period of time, after handling so many cases, we realize that, when we're thinking from our perspective, right? There are different kinds of people, different perspective, different from different places they are coming, spaces they are coming, different needs that they have, right? And monetary could be one of it. Of course, the lawmakers had thought that through, and that is why what Noopur is saying is that it should be open. I also agree to it because we do not know which situation they are coming when this is happening, and not everybody wants monetary compensation, but there could be somebody who really wants it. So it is for us as an IC to make a decision that what can we do. And as you rightly said, that we need a good trained set of ICs sitting there.
As you said, Smita, we also had a very recent, organizations. We have had organizations who say that we do not want monetary compensation to be a part of the PoSH policy. We don't want our employees to know that. It will depend on the IC. It can be at IC's sole discretion if they want to involve that or not. But then there was this one organization who was very sure that they want their employees to know that they have an option of monetary compensation. They made us put it in the PoSH policy. So I think somewhere the organizations are now opening up to this. They wanted to be involved as much as the victims wanted.
And that is what was my perspective also when I had given one perspective, which you must appreciate that, there are some organizations who are thinking in line of giving monetary compensation. So if they put a cap it and if they put a maximum limit to it, what's the harm in it? This is also one point of view, and it actually depends on from organization to organizations. People are not, very simple. They are highly complicated. They are highly unpredictable. So people are very different, and we must respect the differences. And ICs, yes, ICs have a very important and very good, I must say that about the beauty of this legislation is IC have discriminatory power. Kudos to the ICs. Kudos to the skilled IC members. But still, there is one point of view. If the organization is telling the IC members or their legal cell to draft a policy in which you're gonna cap at least the maximum limit what can be set, so that can be also accepted as a suggestion.
True, very true.
Because this is an
That
open
is the
forum, and we are brainstorming the pros and cons and on the topic which was not discussed and which generally organizations do not discuss. And again, kudos to Kelp that we are discussing over here. And I would also request any of the participants who want to speak or have their point of view, please, you can raise your doubts or your insights.
Yeah, sure, we can do that. But just before that, let's sum up this particular discussion session that we are having. So coming to the last question, that one question that I had, like any of you can answer that. Like, do you think there should be any changes or amendments? Like until and unless the law actually puts down some amendments when it comes to monetary compensation, I think it's completely left up to the organizations how they deal with it. But do you think there should be any changes or amendments?
I think not in the law, but they could have a working guideline that
I was
how
about to say that.
how do you determine the monetary compensation? Because there could be an FAQ, there could be a nice working document. Because see, we are dealing with so many IC members from so many thought processes. They are not sure. And Sakshi, you gave an example. Some organization want it put out there. Some organization do not want it put out there. So if we can have a working guidelines that what does monetary compensation mean? What is the thought process when we determine that? That also the logic. How should IC members be thinking? I think if that is there, I think we
Will
are.
be really helpful.
Yeah, so even I just want to add, actually, I was thinking on the same line that not in law, but there should be some guidelines. So when I was preparing for this and I was looking through the judgments, I was also going through so the mental trauma, emotional distress, they are generally also calculated in the cases of like MACT. motor accident, because there also it is one of the criteria on which basis of which they have given. And the court, what I have gone through many judgments, and every time the court says it's based on the facts and circumstances. They should not cap it. For some things, yes, like we have like loss of few job and loss of career opportunity, medical expenses, psychiatric expenses, we have, even they have. So we have a similar type of situation. And similarly in MACT, they are always like, okay, for emotional distress, for mental trauma, they leave it on the case to case basis. And I had seen courts giving, and similarly like in a consumer cases, many times they even go there also, mental harassment and this. And the court is always discretionary on their power, like, okay, we sometimes they award only 5,000, sometimes they award 5 lakhs. There is no actually calculation based. But if there are some guidelines by the ministry or somewhere that what all aspects can be looked into while this, not obviously that has to be comprehensive on this. And we can see that, like for example, in a best practice way, what I was thinking, sometimes even the organizations give counseling sessions to the victims. So even that can be considered, right? So because that is maybe expenses by organization, but you are considering that the victim is going through those counseling sessions, and her work is hampering or not, or whatever is this, she is requiring that. So there can be few factors which they can tell us in a guidelines, that what all factors we can look into it while giving the thinking about the mental trauma and emotional distress point.
That's an interesting point what Noopur has raised, and there are questions around that. That should the cost of proceedings be shifted to the party,
Very
to
interesting.
the respondent,
Interesting. Seriously. Good point of view.
who has and take it as compensation, because you are pulling out the members and they're losing out on hours, even external members to be paid, there is a room set up, there's a cost of having this. So should that be so it's a good thought process, right?
Yeah, in
Yeah.
fact, like
Can
in
be
the
included. Why
litigation,
not?
Smita,
Oh,
as in the litigation, at the end, when the judgments are pronounced, sometimes court gave the award, the cost imposed on the plaintiff or the respondent.
dependent.
So yes, defendant, they court generally impose. No, not obviously they cannot give the huge, the whole system cost, but yes, they put some cost on that aspect also. Because of this case, like you rightly said, people are pulled out from their normal work into IC. Sometimes IC members are sitting late in the night to ensure the confidentiality. They have to arrange the different system to maintain the confidentiality. They have to pull out so many resources for it. The work got hampered, because otherwise, are you expecting IC members? What are you expecting, that they are doing their whole work also? The projects which they have to do, deadlines are there, and apart from it, they are doing this also. What about the mental health of IC members?
We've had IC members saying that this is the serious
Bang
thing that
on.
we do for our organization.
Right.
So I think that's really important. Everybody should be considering that. Okay.
But actually it is not given in law.
It
This
is
is
not,
not
it is
given.
not given in law, but it is a good point that, as respondent, if I think that will be more deterring
Right, absolutely.
for a person to get involved. Imagine sometimes our cases are running for 3+ months, so many hours of work, and imagine the compensation amount the organization is fueling in, right? The reason
Absolutely.
organization is not getting into this because they think, oh, there'll be a lot of expense. But here, if it is pushed to the perpetrator, and if it is a false complaint to the complainant, then I
Yes.
think
Why not? Why
what
not?
We'll get good outcomes there. Okay.
So, wow. So mindfully thought.
Thank you. Thank you so much for all the discussion and pouring on all your experiences and knowledge. Thank you so much.
actually there are questions on the group.
Yes, that I was about to get on that, Smita. We have a lot more questions here. So, like, we are already over time. Should we be taking this, or can I just request these questions to be, mailed to us, or you can just ask in on our website? We can reach you out there.
That would be helpful because we are 1 hour plus and we have
Yes.
blocked our
We had a very great discussion
and
and
lot
this
of
topic was very nice. So
A lot
we
of
would-
insights,
Yeah.
I must say.
I would appreciate all the participants having questions. You can reach out to us. We'll definitely get back to you.
Okay. I
Thank-
think Ankita has posted where we can reach out to them. Thank you very much, Ankita, for that. And
Thank you. Thank you, Ankita.
thank
Thank
you.
Thank you.
Thank you, everybody.
So much for taking out time, Namrata, Noopur, Smita. Thank you so much.
Thank you. It was a
Our
great.
pleasure. Thank you.
It
Always
was
lovely to speak
Thank
to
you, team.
Namrata and Kapoor. Thank you, Toshit.
Thank you.
Thank you, everybody. Thank you.
Thank you.
Thank you.